Steve Hook and I will spend our time with you this afternoon providing you with a brief explanation of the Supreme Court's ruling, summarizing the provisions of healthcare reform that will soon be implemented, and discuss how healthcare reform will impact employers, the healthcare industry, and how to prepare for it. Healthcare reform was signed on March 23, 2010. Within minutes, Florida's Attorney General, along with 12 other states, filed a lawsuit challenging the law. Later, 13 other states joined. November 14, 2011, the Supreme Court agrees to hear healthcare reform law. And then March 26, 2012, the Supreme Court hears oral argument. Finally, on June 28, 2012, the Supreme Court issues its 5-4 ruling upholding most of healthcare reform. The media focused primarily on the issue of whether or not the Supreme Court would find that the individual mandate would violate the Commerce Clause. The Commerce Clause allows Congress to regulate interstate activity. The argument was that Congress did not have the power to regulate inactivity. The Supreme Court held that the Congress violated the Commerce Clause, but upheld the individual mandate by finding that it was permissible use of Congress's authority to tax. A lesser heard about provision is the Medicaid expansion provision in healthcare reform. It would have required all states expand Medicaid to cover more individuals or face losing all of its federal funding for Medicaid. The Supreme Court said that the Medicaid expansion of healthcare reform could not take away existing funding, but could require states to expand Medicaid in order to qualify for additional funding. The Court decided that for purposes of this law, the Anti-Injunction Act did not apply. It decided that since the Congress did not call the penalty a tax, the Anti-Injunction Act did not govern. Finally, the severability provision said the Court did not apply this because no single provision was actually struck down within healthcare reform. For those of you who haven't read the Supreme Court opinion, I'm sharing some important quotes from the majority opinion. In the first quote, the Court makes clear that they're not deciding whether or not this is good policy. Mitt Romney noticed this as well when he addressed the country within moments of the ruling. The second quote, not our job to protect the people from the consequences of their political decisions. Again, Mitt Romney included this in his speech by saying, if you don't like Obamacare, then get rid of Obama. The final quote, as it relates to whether the Medicaid expansion exceeded Congress's power, Justice Roberts struck down a portion of this provision by saying that the Medicaid expansion provision did not contain a mere mild encouragement, but rather compared it to holding a gun to the heads of the states if they didn't expand Medicaid. These quotes are important because the U.S. Supreme Court justices select their words very carefully. They're not just random comments made within a document that will be read and reread and debated for years to come. These quotes can help Americans understand why the Court ruled the way it did.
Making this topic exciting can sometimes be a challenge, so we thought we'd put some questions in here until it's for Jeopardy soon. So we've included some questions to test your understanding today of healthcare reform. At the end of the webinar, if you can remember all of the right answers to the questions that we're going to be going over, you'll actually be within a very small minority of 1% of the population who's already taken this quiz, and we'll share with you the results as we go through. So just respond when you see the question, just respond on your computer, and we'll share the audience results. So the first question looks like everybody's had a chance to respond. When the Kaiser Family Foundation conducted this poll previously, about 27% answered this question correctly. You can see on your screen how our audience did today. So we've got 40% true and 58% false. In the national poll, only 27% correctly answered this is false. 59% said it was true, and 14% said they didn't know. Don't expect that this decision is the final word on healthcare reform, as other lawsuits about the Act are winding their way through the lower court system, and it will probably be some time before the full impact of all these legal challenges are known. Opponents of the law have also vowed political action. In light of the Supreme Court's decision, you need to plan for the future and consider carefully how you will meet the challenges of implementing this Act. Your employees will be looking to you to help them understand what the Supreme Court's decision actually means for them as it relates to your own company benefits. Insurance companies have begun mailing out checks that total $1.1 billion across the nation. This is the first rebate payout from the provision that is required to be paid by August 1st, 2012 for the plan year 2011. Each subsequent year, fully insured products, both individual and group, must be reported and paid if appropriate. The Act requires insurance carriers to spend in claims at least 80% of the premium they collect for individual and small group coverage and 85% for large group coverage. Some, but not all carriers in Wisconsin met the MLR requirements and are mailing rebates for their 2011 experience. Additionally, your employees will also be getting notified in the mail by the insurance carrier if your company is actually getting a rebate check, and this is required by the law. For most employers, they can either return the pro rata employee portion to the employees in cash, or they can reduce future premium contributions. Beginning this fall, plans renewing after September 23rd, 2012 will be required to provide the new Summary of Benefits and Coverage, also known as SBCs, in the required 4-page format. Insured plans will be prepared by the carrier, and self-insured employers are responsible for preparing your own. It's likely that your TPA or administrator will offer this service. There may or may not be a charge for it. Employers are required to distribute the SBCs as follows: to all plan participants, employees and former employees; to all plan beneficiaries, spouses and dependents, including COBRA beneficiaries, and the distribution can be either paper or electronic format. And a single copy is permissible or allowed for everyone at the same address, but for plan beneficiaries at addresses other than the main address for the employee, that's the responsibility of that beneficiary. For plan years beginning in 2013, the Act now limits the maximum amount that you can have in a healthcare flexible spending account, or FSA. The new $2,500 annual limit applies only to salary reduction contributions. So if as an employer is offering any additional non-elective contributions, sometimes called flex credits, those are not included in the $2,500 limit. Also, the W-2 reporting, which was delayed implementing but now is effective for tax year 2012 for everyone, must include the cost of the medical plan in box DD in your form's W-2s. The reporting does not increase the taxable income for any employee. It only identifies the total cost of the health insurance for the employee and any dependents that may be covered. One advanced question we received on this topic asked, if an employer is offering an HRA alongside their medical plan, do they have to include the contributions to the HRA in the amount reported? The IRS answered this question in one of their Q&A documents by saying no, that's not required. You only need to include the coverages that are on an integrated basis. And so if you have a dental and vision coverage that's integrated with the medical from a plan perspective, then all of those coverages need to be included. But if you have freestanding dental and vision, then all you need to include includes just the medical. And by March 2013, you're going to be required to inform all your employees about the new health insurance exchanges. Those will be effective in the fall of 2013 with an effective date of coverage of 1/1/2014. In Wisconsin, our governor has already stated that he doesn't plan to operate a state-run exchange. So, and this is going to be a statewide basis. So if you have employees in other states besides Wisconsin, we're going to have to keep track of whether or not you have a state-run exchange or if you're going to have the opportunity to participate in a federal exchange. And we're going to talk more about the exchanges in a few slides.
Looking forward to 2014. Most of the discussions around the individual mandate have been about whether or not it was constitutional. Well, now that's going into effect beginning January 1, 2014. What is it? The individual mandate applies to individuals who do not have a qualifying health plan beginning January 2014. If so, they have to pay a tax. If they don't have coverage, they have to pay a tax. The tax is the greater of 1% of income, or $95 per person in 2014, $285 per family. Beginning in 2016, it goes up to the greater of 2.5% of income, or $695 per person, or $2,085 per family. Some individuals are exempt from the individual mandate. For example, individuals who are undocumented immigrants will not be charged the tax. If a person is not filing taxes because their income is below the threshold for filing taxes, they will not be charged the tax. People who are incarcerated will also not be charged the tax. Prior to the Supreme Court's ruling, it was estimated that 4 million people are expected to go without insurance even after health care reform. It was also estimated that the individual mandate would result in revenue of $4 billion in taxes to be collected on an annual basis by 2017. In light of the Supreme Court's ruling and discussion about the lack of the IRS enforcement power to collect this individual tax, it's likely that more people would go without coverage and that less people will pay the tax. And we have another question for the audience. And the audience said, well, this one's a trick question. It depends. It's a trick question because it depends on what state in which you live. The Supreme Court's decision will not allow Congress to force states to expand Medicaid. So states have a choice. If they expand Medicaid, they receive additional funding from the government, federal government. Wisconsin, Louisiana, and Florida have already stated that they will not be expanding Medicaid in their state. The governors in each of these states are Republican. That kind of explains maybe their decision to do that. So Medicaid expansion. Who is currently eligible? Currently, low-income parents, children, seniors, and people with disabilities are eligible. Currently, the income is determined on a state level, so state by state. Under health care reform, if Medicaid is expanded, low-income individuals, not just parents, can also be eligible for Medicaid. Income will be determined on a nationwide basis, so not state by state. Under health care reform, assuming all states were required to expand Medicaid, by 2019, it was expected that Medicaid enrollment would increase by 15.9 million individuals. One estimate states that federal spending would increase by $443.5 billion, and state spending would increase by $21.1 billion, just between the years of 2014 and 2019. Therefore, about 95% of all new spending would have been done by the federal government. If a state doesn't voluntarily expand Medicaid, individuals that may have been eligible for Medicaid will be able to purchase coverage on the exchange. And we have another question for the audience. Okay, and we have the audience response. I'll go ahead and share it with you.
Well, that's pretty close to what the Kaiser National Survey got back on this question. When they asked these questions, 67% had the correct answer of A, 25% thought the answer was no, and 9% answered they didn't know. This has been one of the most publicly favored provisions, also referred to as guarantee issue. No longer will people be rated up or have limited coverage due to an existing health status after 2014. It was also the reason the writers of the bill did not want the bill to be severable, fearing that without a strong penalty to force people to buy coverage, people will wait until they're really sick before buying coverage, driving up the cost for everybody that's in the insurance pool. More on the exchanges. The law establishes a new marketplace called the Healthcare Exchange for individual and small group insurance buyers. Beginning in 2014, insurance companies will no longer be able to ask medical questions in underwriting health insurance. Every applicant will be accepted without regard to any medical history. People will be able to shop across all the carriers offering product in the exchange and choose the plan and carrier that best fits their needs. New rating rules will apply in 2014 that will limit the factors insurance companies can consider in setting rates, and additional rating reviews have already taken place that provide more oversight on what increases insurance companies can charge. The effect of these changes are expected to provide more rate relief to older people at the expense of younger enrollees. This will further burden the affordability problem for those least capable to absorb the increase. Excuse me. Additionally, the exchanges will serve as an exclusive agent for 4 different programs. First of all, the Medicaid enrollment. People applying for Medicaid will go through the exchange and go through the review, the income requirements, and the eligibility provisions to be able to access Medicaid. The other component of the new government subsidized health insurance, people who are eligible, and we'll talk more about this in a couple of slides, those that are eligible for assistance through the subsidies, the only place you'll be able to take those subsidies or get those credits will be through the exchange. It will become an option for individual purchasers that earn over 400% of the federal poverty limit but are wanting to purchase coverage. They'll have an option to either purchase it through the exchange or individual carriers directly. And then lastly, the option for small employers with less than 100 employees will be able to use the exchange to purchase their coverage if they choose to. The exchanges, either state, regional, or federal, will be running and be open in the fall of 2013 for a 1/1/2014 effective date. Large employers are expected to be able to use the exchange possibly by 2017. The exchange is designed to be accessed via the internet and telephonically.
We have another question for the audience. poll results are in.
For a subsidy to help them buy health insurance. The law, as originally written, expanded Medicaid to 133% of the federal poverty limit. However, it was talked about, the Supreme Court ruled against that portion of the act and is not allowing the federal government to penalize the states that don't want to expand their Medicaid eligibility. Many states have already stated they don't want to be forced to expand Medicaid and take on that financial liability, even though initially the federal government was offering to pay for most of that coverage. So each state will continue to have different eligibility rules that presumably will alter the number of people eligible for both Medicaid and the federal subsidy on a state-by-state basis. For people below 400% of the federal poverty limit, working where an employer offers a qualified plan, they will not be eligible for a subsidy unless the cost from their employer, i.e. the employer contribution, of the least expensive option available to them, if that option is more than 9.5% of their income, then they'll be eligible to purchase it and get a subsidy on the exchange. Rates on the exchange will be age and area rated. So the subsidy amount will increase as the age of the participant. Said differently, more older people who take advantage of the subsidy, the higher the cost will be for the government, aka the taxpayer. Conversely, as your income increases, so does the subsidized cost, thereby reducing the subsidy for the government, from the government, until it reaches zero as you start approaching 400% of the federal poverty limit.
Okay, we have a question for the audience. Okay, and the results are in.
This was the most difficult question nationally when only 25% correctly answered B. Also, this was the most wrong at 65%, and 10% didn't know. One of the ways this law generates revenue that makes this one of the largest pieces of tax legislation in the world's history is to require employers with 50 or more full-time employees to either buy insurance or pay a tax to help fund the subsidies for the working poor. One of the most significant requirements to be implemented in 2014 is referred to as the pay-or-play fine or penalty tax on employers a rule which applies to companies with 50 or more full-time equivalent employees. Under the individual mandate, all individuals will be required to maintain minimum essential coverage in 2014 with certain exceptions that Renee mentioned, whether this is obtained through their employer, through their spouse, or through the insurance exchange, or directly from an insurance company. Individuals who fail to satisfy this requirement will be subject to a tax that varies depending on their income level. The pay or play penalty will kick in for employers when the employee receives a subsidy or the tax credit through the state or federal exchange. If an employer chooses not to offer a qualified plan and the employee obtains coverage, any employee, through an exchange, that company will be fined $2,000 multiplied by the number of full-time employees you have minus 30 employees. If an employer does offer a qualified plan, but it's determined to be unaffordable, as defined as single coverage over 9.5% of an individual's income, employers will be fined $3,000 for each employee that seeks a credit to purchase coverage through the exchange. These fines will be capped so that it doesn't exceed the fine for an employer as if he hadn't offered any coverage at all. Employers wanting to avoid paying a penalty only need to focus on meeting the qualified health plan design requirements and making sure that the employee contribution for the least expensive option offered is below 9.5% of the employee's income. This provision has sparked a new interest in a lot of employers to set employee contributions as a percent of income instead of a flat dollar amount per person. And it's also made some reconsider the amount that the employer is willing to pay for dependent coverage versus employee-only coverage. The Act has introduced several new factors employers have to be aware of in designing their benefits. One of the most complex things has been the introduction of a family income as a determinant of eligibility of the subsidy on the exchange, and the impact that has on the pay or play penalty. Most employers have no way of knowing how much the family income is, and the IRS created a safe harbor provision that eliminates that $3,000 penalty if the employee is eligible for a subsidy solely because of their family income status. So as long as the employee contribution for the employee-only coverage is below 9.5% of their personal income. So while in this situation, employees might be getting coverage subsidized through the exchange, it will not activate the penalty for that employer.
Okay, we have another question from the audience. We'll close the poll. And the results are, when respondents answered the same question for the Kaiser Family Foundation, 65% said yes, 22% said no, and 13% did not know. And the correct answer is yes. Beginning in 2010, the small business tax credit became available to employers who had less than 25 employees and paid at least 50% of the cost of single premium. Tax credits in the amounts between 35 and 25% were made available. Beginning in 2014, the tax credit amounts will increase to 50% to 35%. A calculator is available on the IRS.gov website to help employers determine if they are eligible. And we have another question again for the audience. polls. And the results are, again, the Kaiser Family Foundation asked the same question, and at that time 42% said false, 41% said true, 16% did not know, and the correct answer is false. The continued debate around healthcare reform. Is the future of healthcare reform certain? It's too soon to tell. While the court's decision makes it highly unlikely that healthcare reform will be repealed, we expect the debate to continue. Mitt Romney has promised to repeal healthcare reform if elected president. Healthcare reform will continue to therefore be a topic of the debate during the presidential election. It's also likely that candidates running for state offices this fall will be discussing how they would vote on an attempt to repeal healthcare reform in Congress. The House of Representatives vowed to schedule a vote to repeal healthcare reform after the Supreme Court's ruling was released. Even if it passes, remember that both the House and the Senate must pass the same law by a 2/3 majority vote in order for it to become law. And even then, if Congress were to pass a 2/3 majority vote in both House and Senate, President Obama would veto it.
Many of the health care reforms in the law have provisions require agency guidance to be implemented. The Departments of Labor, the Departments of Health and Human Services, and the Treasury Department have been regularly issuing guidance to implement the health care reforms. These agencies will continue to promulgate regulations relating to the health care reform law, and employers and health plans will be required to comply with these to the same extent that they are required to comply with the various provisions of the health care reform law that we've already seen enacted. Additionally, members of Congress have already introduced new legislation to amend and repeal various parts, and likely will continue with this strategy. Each of these possibilities may have an impact on how healthcare reform actually gets implemented. There's very little in this law that really makes healthcare affordable. The Act has already created a national high-risk pool. While here in Wisconsin, we already had such a program that was subsidized by insurance carriers, these programs, both locally and nationally, will be eliminated in 2014, and they will dump all these very expensive participants into the individual pool. Additionally, in 2014, Medicare, underage Medicare folks that really want to retire will no longer be staying at work just because they can't afford or can't find health insurance in the private market. All of these people will be eligible for guarantee issue and will have access to subsidized health care as an early retiree. These typically are the most expensive people you have in your plans today. They will also be joining the individual pool. Remember, in 2010, as healthcare reform was first rolled out, there was a provision that provided $5 billion of federal grants to employers that had early retiree coverage that they could apply for. It was anticipated that this $5 billion fund would last many years, but it was oversubscribed to almost immediately when the applications began being accepted. And don't forget that as HHS continues to expand the definition, they've continued to expand coverage, as they recently did with the enactment of the definitions for women's preventive health benefits. All of these things will significantly add to the increased affordability problem. The most important thing that employers can do today is to talk to your employees about this court decision and how it'll impact or maybe not impact your employee benefits in the near future. The polls are very clear that have been taken about from the public standpoint. People don't have a very good understanding of what the facts are in the law. And even without really understanding it, the majority of people who take these polls say they don't support the act. Your employees want to hear from you, not from political pundits. Let them know that you're going to be working closely with your insurance broker and advisors to come up with a benefit program that meets the challenges of the new law. The new tax associated with the individual mandate will increase the value your employees will place on your benefit program, so make sure you're getting the appropriate credit for this valuable benefit in your total rewards program.